understand the persons who are on a higher pedestal to understand that. Because as we all say that if the foundation is strong, then the building is strong. So to understand from a person who can make the foundation strong is, I can say, fundamentally one of the most fundamental thing to be understood. And there couldn't be a better occasion to understand as to how the contract agreements and public policy as such would be there. And once we have a speaker who is also known not only for his knowledge as well as for the way he's an erudite manner he expresses it in a simplified form. Without taking much time, I would request Sir to take things forward, because students are, I will say students, not only the students of law as such, but all those who join us on the live law, that is on the Facebook, YouTube, they're all students who are wanting to learn. And before that, we would all request again what we have also written on our invite: keep maintaining the social distancing, keep wearing the masks, and contribute to the society at large in whatever manner you can do, economically, physically, emotionally, because the way things are going on, even a mental support and an emotional support is enough to support a person. As I am reminded, a famous dialogue of Shah Rukh Khan, "Main hoon na." So just give that word to a common man, that "Main hoon na," it gives the spirit a pep up. And there's another feeling that immunity is one of the important facets of life. And they say if you are happy and you can make people happy, that brings the immunity level to much better than even the medicines. We can go all gaga about immunization, that you should go for vaccination. But right now we have to understand how the contract agreements and public policies are on important aspects as a lawyer, as a judicial officer, as a judge, to understand all those, to have a bird eye view in a 1 hour session round. I would request Sir to take things forward.
Vikasji, I need to share the screen, so you have to give me the first strikes.
It's allowed.
Good evening, and thank you very much for that warm introduction. I must first of all apologize to Vikasji, because he has literally been chasing me for a session for a couple of months, and due to my pressing schedule, I was not able to come to this platform, but we have it right now. His his ability to get the best minds to share the idea of law and the knowledge of law is something that I keenly have followed, and I personally appreciate him for all the efforts that he has put in bringing this lecture series together. I should also thank all the participants to having joined me today evening. These are tough times, tough, challenging times around us. It's not easy to focus on academics or a learning environment with so much that is happening in this pandemic around us. We all, in one way or the other, have been affected by the loss of somebody who is very near and dear to us. The pandemic has shaken. Many of us have been tested positive. We should remain positive, not only testing positive. So I think if you have taken time to join this session, let me personally thank you. It's encouraging. From the participants list, I see a lot of my students. Now I'm a little worried, because if you're giving a lecture in front of students, they are pretty smart, and they tend to quiz you, question you on the right things. So let me see if my students can actually interact with me today. Friends, I have no intention again to give a lecture. I don't believe in giving a one-side lecture. I think we should get into an interaction. We should get into some kind of a discussion. I think it's a mutual learning environment. This is not a classroom environment. So I think if you guys need to share an idea, put across your views, I think I'll be more than happy to receive those suggestions and those comments and those ideas as well. So please keep this session as interactive as possible. I would encourage you, in whichever platform you can do that, through the use of the chat box, or if you're allowed to unmute, please do that. So we'll keep this session in a dialogue format, and I prefer that. Friends, the topic that I've chosen is something that is very close to my area of research and practice, and very close to what I've written a couple of years back. This is the cover page of the book. To be honest, it's a edited work. Most of the writings are from my students, who have written articles on different aspects of contracts and public policy. And I'm just going to take a clue from this book itself. You will find this book online. It's there for your read. If anybody wishes to read about what is going to be spoken today, I would request you to go to a website called nlspub.ac.in. Okay, nlspub.ac.in. Now, I'm sure in North India, and many of us think pub is something else, where the bar is there. But friends, the pub here means publication. So don't take it otherwise, right? So it is nlspublication.ac.in. That's the website. You will see the soft copy of this book. And most of the cases that I'm going to refer to, friends, in terms of illustration or case studies or case examples, are all part of this book, right? So I'll be using some recent cases in the last 1 or 2 years when I give you some illustrations of what I attempt to speak about. So friends, when I decided
just press the hourglass figure so that now it's fine.
Yeah. So interestingly, friends, we are talking about today the concept of public policy in contracts and agreements. Now, as lawyers, as practitioners, as law students, as somebody who is in the legal fraternity, I'm sure contract was our basic subject. It was the foundational subject. And we went on to discuss a law called the arbitration law, which happens to be the more practice subject, right? So, ADR, arbitration, comes later on. And, interestingly, right from the first year to the last year, I'm sure very often than not in law schools, you would have come across this term called public policy, right? Now, the term public policy is interesting, right? Interesting for several reasons. And among them, the reasons are that, when you look at Section 23 of the Indian Contract Act, the determination of public policy is left to the courts, the judiciary, right? So this section very clearly says that the judiciary and the courts may determine what is public policy in contracts. Similarly, when you go back to the ONGC case versus saw pipes, what the Supreme Court said, how it can intervene in arbitral awards, how it has intervened in taxation matters. I think the Supreme Court time and again, or the judiciary as it were, time and again has defined or attempted to define public policy, or has probably intervened on the ground of public policy, right? So this is like a judicial weapon, if I can use that term, if I'm permitted to use that term, is a judicial weapon to actually try and intervene in private matters. It's quite amazing that this term, that is public policy, has been defined to be quite an unruly horse. And this is not something that is used by Indian judges for the first time. It has been used by American judges and by judges in United Kingdom as well. Because the challenges of defining public policy remains across the legal system. And the judiciary, like a whip of public policy, can intervene into private matters and hold that private matter as not being enforceable or as not being valid. However, from time to time, I think the judiciary has attempted to probably say what is the test of public policy. Right? 1, 2, and 3, fundamental law of the land, security of the state. So they have defined, they have said, okay, based on this, we will say that this award or this act is not in favor of public policy. But the point is, have we really understood the term public policy? Do we know what it means? Can we clearly categorize this as what is public policy and what is not public policy? Is there certainty in trying to understand this term? Do we know which kind of contracts or agreements public policy can be challenged? And the most interesting part is, when we look at the aspect of public policy, somewhere down the lane, we think about 3 things, right? First, we think about public interest. Public policy is public interest. That's what, a lot of authors have attempted to say, and it has been said in few judgments as well. Secondly, we say public policy is public morality. I'll tell you what this morality seems to be vis-a-vis public policy. And the third thing we say public policy is, kind of national security or national interest. So no, there is public interest, there is public morality, and there is public security. There are three aspects to this public policy. So when you talk about this interest, morality, and security, is that a sufficient test for the judiciary to intervene in contracts? Now, there are a lot of writings and criticism of this. Right? A lot of people think that this is quite a thing that should not be interfered with. And a lot of people think that this is not the right thing. We should have something else. The public policy test does not give certainty to understanding of the law. But to be honest, if you ask me what is public policy, I have always felt that it is a guardian of rights. Right? This is my way of dealing with public policy. I always have believed that public policy is nothing but a guardian of rights. Where the court feels that rights have to be protected on the ground of public policy, they have intervened. And there are numerous examples about it. And hence, I must say that the judiciary has used this as not only the custodian of the Constitution, we say that the judiciary is, but it's also judiciary is the guardian of rights. And public policy is one such element in which the judiciary gets moral, ethical, and legal authority to intervene in protecting rights of individuals. And that's where probably there is some kind of a justification of the use of the term public policy and giving the courts the right to do so. I did attempt to list out the issues that we will discuss for the day. And the issues are, before I come to that, I was just going through and trying to ask my colleague to get me some information about how many times the courts have used public policy in their judgment. Now, this is not in terms of, say, they have used it as a ratio, but they have generally, looked into discussions. And so this is just a random search. First, let me tell you, I did look into a very interesting article of 2016 from the United States. And the author, and from there I got this idea, he actually searched that how much did the US Supreme Court use the term public policy. And for a matter of nearly 40 years, he said the US Supreme Court used the term public policy nearly 7,000 times. Right? So they have used that terminology nearly 7,000 times. That was what his article had to suggest. But remember, this is not public policy vis-a-vis contract. It's public policy that has been used in all kinds and forms of cases. So I tried to research about how much did the Indian Supreme Court use this from 1951 onwards. And I found that the Supreme Court has used it in 611 times, which probably clearly tells that it is quite popularly used in cases. And it is probably one of those challenges that is taken up before the courts. So if the courts have taken it for 611 times, that is the top court, I'm sure the lower court should have used it for more number of times. This clearly now shows that the term public policy is of some interest, and I think we need some attention to understanding this. We have to play some significant role in defining this, probably looking at its application as well, right? Okay, so I'm going to start off with one of the illustrative cases that came before me, and I'll just try and probably share it with you. So we had an interesting case about an institution that employed an African national who was here on, a student visa, but they employed him. And of course, I'm not sure whether when you have a student visa, you are allowed to work. And, there are some challenges about his employment. He was not paid later on for a couple of months by the institution. So obviously, he had qualified himself in law. He had done his PhD in law in India, please know. So as a lawyer, he said, this is not done. I am entitled to this payment. So he does serve a legal notice for the remainder of his payment. And later on, the matter comes for an adjudicatory process. The first thing that was asked in this case is, could he be under employment? did he have the requisite legal documents for employment? He was here just to study, but he got himself employed. Now he's seeking enforcement of a contract because he's asking his dues, and he's asking for payment of his salary. And now suddenly the institution, defends and says, look, this is a contract that has to be held void, and it's not in public policy at all, because this guy is not legally entitled to work in India. And hence, because this is void, he cannot actually make a claim for his salary. Now, I think when we talk about public policy, friends, interestingly, when I look at what public policy can mean, if suppose there is a migrant, staying in India, can you enter into a contract with a migrant who probably is not legally entitled to stay in India, right? If his stay is illegal, can a contract of employment be made? Now, I believe that when I said that public policy can be public interest, public morality, and public security, please note, when we apply the term public security, I have tried to do some kind of research on what public security can mean, and can this case come under public security? Because please note, you are violating a given law, which probably does not give you, the permission for employment, right? And in this case, whether the candidate who's seeking enforcement and salary, and whether the institutions have violated a given law of the land, to some extent, yes, they might have done so, right? And hence, in this context, if the adjudicatory body has to determine that this is a contract that is against public policy, because it encourages people to come on one visa and work, and that is not really something that the state should encourage. That is not something even citizens of any country should encourage. To some extent, then we try and understand, oh, fine, this is how public policy in contract should apply, right? So I think to some extent, in all of these, when I talk about the role of the courts, I find the courts have played a very significant role, a very, very important role. And in some cases where probably, they have upheld public policy, in some cases they have not. But I think they have reasons why they did not do that. So the courts have played probably a very significant role in probably adjudicating matters and saying this is what public policy is. To be honest, friends, public policy is like, it's like a protectionist policy, right? It tries to protect the interest of different stakeholders. For example, it can protect the interest of the parties to the contract. It can protect the interest of third parties, that is outsiders. It can protect the interest of the state. Like in the example that I gave you, if public policy has to be protected in that contract, it is the interest of the state, it is the interest of the government, it is the interest of the society that the adjudicatory officer had to protect, right? So you can't encourage such kinds of contract because they are in violation of a given law, right? So I think the courts then definitely have a clear role as defined to either see that, yes, we are in favor of this, or we may not be in favor of that. Interestingly, time and again, we have seen public policy being adopted by the courts and in different matters. I think, if you look at the taxation matters of Vodafone, the Cranes Energy case, the different kinds of arbitral awards that is being challenged right now, very often than not, when public policy is applied by the courts, I do not have so much of a problem. But today, most of the commercial matters are going to arbitration, and the arbitrators now are getting very powerful in application of public policy. The commercial courts are getting very powerful in the application of public policy. So when the top court does it, there is a lot of transparency, there is a lot of scrutiny, and it's a reportable judgment. But when an arbitrator decides to apply public policy, unfortunately, unless the arbitral award is challenged and the challenge is accepted, the scrutiny in public is not there, because arbitral awards are usually confidential in nature. In those circumstances, how that public policy is applied becomes a very critical issue in many of these cases. And hence, some authors believe that this term public policy, because it's not so much defined, has given unreasonable powers in the hands of the arbitrators to decide certain matters. And is it good? Not sure, right? Anyway, that's the other side in which we have to evaluate whether we need some kind of a legislative understanding of what public policy is. Let's take certain other examples, and let me share with you the fact that when I say uh, okay, today, interestingly, we are all experts of public policy. We have attained expertise. Uh, and COVID-19 has helped us all to become experts in public policy. But we have become experts in public policy of health, thanks to COVID-19. Each one of us has an opinion on the vaccine pricing. Each one has an opinion about the second dose. Each one has an opinion about what should be charged. Should it be free? Because public health is public policy. Right. Now, if I just take an example of public health and public policy, I'm reminded of this National Pharmaceutical Pricing Authority. Not many of us actually know about it, and that's the reason I've taken that example. National Pharmaceutical Pricing Authority. This is an authority that actually fixes prices for essential medicines, life-saving and others. There are a lot of drugs. More than 400 drugs have been listed under this pricing authority. And basically what we do is we fix prices, right? Because they should not be profiteering from this. So pharma companies have to sell it at a fixed price. So that is that regulation on public health and public policy. But the question is, if there is an attempt, please note, to sell these life-saving pharmaceutical medicines beyond the price that is fixed. So if there is a contract, if there is an agreement, obviously we'll all say that this is an agreement against public policy, because pricing, please note, underline, is of public concern. It's not only contracts. Contracts has different elements. Price is one of the elements in contract. It's one of the elements in contract, right? So if the prices are, say, not that the policy expects you to charge, right? That kind of an agreement or a contract is actually supposed to be against public policy, right? And hence, when I apply the pricing mechanism, one of my students asked me, said, if a contract is against public policy, so if it's overpriced, right? Because the law fixes a price. Now, I'm sure you know that COVID vaccines, there is a price cap, right? I'm sure some of us has paid it. The Sputnik V vaccine also is price capped. I'm not sure it's capped or is it market driven. Anyway, there is a price to it and the government may regulate that. Now, once there is a regulation, anything that is above it against public policy. Right? The point that all of you have to note is, if it goes beyond it, whether the contract is illegal or merely void. Because please note, friends, if a contract or an agreement is just against public policy, it does not make the contract illegal necessarily. It makes the contract only void. Right? So public policy is not about creation of a box of illegality of acts or conducts, not necessarily so. It is only trying to regulate the wrong behavior, right? Correct the wrong behavior if possible, and that job is given to the courts. So public policy tries to say, okay, look, this behavior is permitted and this behavior is not permitted. Because interestingly, friends, what contract has become today is, to be honest, sometimes contract becomes an instrument of exploitation, where the iniquity of bargain, right now there is a huge demand and supply gap, right? Now the demand is more of vaccines and supply is less. Because of this iniquity, a contract could be used to exploit consumers and citizens. Right? In those contexts, I think the protectionist policy of public policy, protectionist policy has to come in place. Right? And that's the basic reason why I believe that when it comes to the guardian of rights or guardian of protecting rights, public policy plays a very critical role. Take the second instance of employment. Most of you in the legal profession would know that the first proper definition of public policy came in the Brojanath Ganguly case, which was an employment contract. Because it was then that the courts realized that employment contracts are subject to exploitation, subject to unreasonable clauses, subject to unreasonable conditions. Because the employer is in a higher bargaining position and the employee probably has to just agree to those terms. Now, an employment contract is a private contract, and why should public policy come in a private contract? Probably because it is important to protect the rights of employees. It's important to send a message across to employers that unless you are fair, reasonable, the contracts will not have any enforceability. But look, from Rojamath Ganguly, I think, friends, we have come a long way. Long way in the sense that today, employers, apply something, what I say is the mischief rule. And that's where, I always believe, can public policy catch that mischief? Always. Right? Because contractual clauses are becoming, very, very unique. There is a lot of experimentation, lot of innovation in contractual clauses of late. There are new clauses that are coming every day. I'm sure some of you have heard about some of the recent clauses. It's not so very recent, but there is a clause called escrow agreements, right? Quite, not something that I had even studied or written. So, there are some very innovative clauses that keep coming. And somehow the employer tries to trap the employee into those kinds of clauses that trap him, right? So I'm sure most of you have seen the clauses on indemnity or employment, where employees have to sign a 3-year bond and give 3 lakh rupees, right? I've always said the public policy in employment bond is about the fact that can the contract be mutual to both the parties? If there are employers in the house, please give me some attention. I've seen some of these employment bonds. What do they say? They say that, Sairam has to work in our company for 3 years. And in between, if he leaves within those 3 years, he has to give 3 lakh rupees. Right? That is generally how it is termed in contracts. But I've asked employers who have come for consultation, I have said, that's fine. If you think, it should be in favor of public policy, how should you draft it? You should say that in case I fire the employee within these 3 years, I will give him 3 lakh rupees. The point is, there is a duty of the employee. That should be a duty of the employer. It should be equal to both the parties. Okay? How can, a contract just have obligation towards one party? Mutuality of obligation, please note, mutuality of obligation, mutuality of liabilities is the cornerstone of public policy. A contract cannot have obligations only for one party, that only he has to do, he is liable, and I have no duties, I have no liabilities. Friends, I did come across a very interesting case of 2019 from the Delhi High Court, in which, interestingly, the contract was made in such a fashion that, liability for damages was completely removed. How it was done, I don't know. Whether it was negotiated properly, whether it was read properly, because in contracts, very often they're not negotiations, reviews, and drafting plays a very critical role. Whether it was adequately done or not, I'm not sure. But the court then simply said, you can't have there is a law on damages. It's giving you that. You can't have a contract which says, what is given by law is not given by the contract. Right? So, a contract cannot in any way diminish rights already granted to individuals and citizens. Right? That's another cornerstone of public policy. Right? If the contract infringes your rights that is already granted by a statute, that's clearly what contracts cannot stand for. They have to be held void. Because the law gives you rights and contracts cannot take away that rights. Please note, when I say take away, they cannot even abridge it or waive that rights. So when employees have certain rights given by statutes, I think they have the right to see it enforceable, despite a contract having been there. Friends, one of the interesting issues of public policy in contracts have always been, and this is quite very popular, and I can ask you this question right now. Let me ask you. I think, when I said dialogue, I think it's the right time to have one. Can I have a choice of law in my contract? What do you guys think? Let me just go and put the chat box on. Can I have a choice of law in a domestic contract? Okay, let me be more specific. Can I have a choice of law in a domestic contract? Is it possible? Okay, so interestingly, in most contracts, there are two things. There is something called choice of forum, and there is a choice of law. Can I have one choice of law in a contract in India? Two responses. Three. Raghavendra is coming with yes. Subramania is also saying no. I don't think so. Okay. Yeah, because contract gives you that freedom, isn't it? You can agree to anything that you want. So let's assume that me and Vikasji are making a contract in India. Can we choose Singapore law as being applicable to our contract? Are we permitted to do that? Interesting responses from all lawyers, I hope. If you're law students, your answers, if they're wrong, forgiven. But if you're lawyers, your answers okay. Saving clause, no. Go back to this very interesting proposition of what I say as the mischief rule. Okay. Now, what is a mischief rule? Under mischief rule, I try to do some kind of mischief in a contract. Try and experiment. Now, for example, me and Vikasji making a contract and we choosing Singapore law, right? Do you have the absolute freedom to choose any law that is applicable to your contract? For example, when we say choice of forum, can you choose arbitration before courts as choice of forum, right? The answer is yes, because the law in India very clearly says that you are permitted to go in for an alternate dispute resolution before you go to the courts. So choice of forum, friends, is definitely acceptable, and it's one of the exceptions under Section 28, right, of the Indian Contract Act. So you have the freedom to choose the forum. You can do conciliation before arbitration. You can do arbitration before courts. That is something that law has always allowed you to do. But what about choice of law? Now you say that I want arbitration, okay, but I want the Singapore contract law to apply. See, as the forum, Singapore arbitration law is the procedure law. What is the substantive law applicable to the contracts? Friends, interestingly, remember, in most other jurisdictions, what is public policy? Public policy is the law of the land, right? Now, if it is the law of the land, how can me and Vikas ji escape the law of the land and take Singapore law because we think Singapore law is best? So when I say the Indian contract law applies to the territory of India, what does that mean? If it applies to the territory of India, does it apply to the citizens of India who are making contracts in India? Are Indian citizens given the freedom to go and choose Singapore law? Friends, please note, I can choose Singapore law, right? But should it have any close nexus or connection to the subject matter of the contract? Or can I randomly choose any other law that is applicable to it? Friends, remember, when you talk about public policy, the point is, if suppose me and Vikas go to Singapore, we do arbitration, that we ask the Singapore law to be applied by the Singapore arbitrators. Then later on, Vikas comes here and he wants to enforce the decree or the arbitral award, whatever. He goes to the Indian court. Do you think the Indian judges will, appreciate Singapore law and say, yeah, apply kar lo, Chandigarh mein, hum isko apply kar denge? Why would Indian judges even intervene in such a law? Because they are not experts about Singapore law. They are experts about Indian law, Indian contract. So, when it comes to choice of law, this is kind of a gray area. Because there are a couple of cases. One is the 2006 case, another is 2013 TDM infrastructure case. There is a WSG case where the courts have very clearly said that two Indians cannot choose a foreign law as a law applicable. This is against public policy. And I believe I go by that judgment. If it's an international contract, you can choose a foreign law. It's possible. But that foreign law, please note, again, is not for you to choose. It has to have some close connection to the subject matter of the contract. It's not like, you go and say, let us choose Kenyan law, African law, or some other. It has to have some close connection to the subject matter of the contract. So I think public policy in certain clauses of contracts are also something that have very clearly been adjudicated upon. Right? So, fine, we just go a little bit further. Yeah. Let's take, public policy in social institutions. Friends, don't take me otherwise. This is kind of my favorite topic. So, you should pardon me if I indulge a little bit more in this. Because, interestingly, I told you public policy is public interest, public morality, and public security. And just taking
dispense with the slide. We can dispense with the slide, I think so.
You don't want the slide?
Because now a lot of people have known, people would like to see you on the full screen. That's what I'm saying.
Okay. That's okay. No problem. Okay. Yeah. Okay. You guys want to see me more than what I have to present? I'm really glad for that. Okay. On the lighter side. Okay. Very happy. Okay. Dr. Mallikarjuna is with us. He is a contract expert himself. So, sir, namaskara. Really privileged to have you, sir. Sir, I was just saying about public policy. Now, now I think it makes sense because I know who my audience is, because I was most focusing on my slides. So, what is public policy in terms of social institutions? I have a couple of examples to share with you, and these are examples that I've always taken during some of my presentations. There was this very interesting case called Baby M case in the United States. It starts from there. So these are what we call as the surrogacy contracts in India. We have a Baby M case in India as well. It is called the Baby Manjis case, the Yamada case. So, when you look at how the United States dealt in that case, the surrogacy contracts case, surrogacy law is about the social institution of marriage, adoption, children. We are yet to get the bill. Please note, the bill is pending. I think the 2019 bill is already there. I'm sure we should get a law in place. But the fact is, all throughout so far, the relationship of surrogacy has been a tripartite contractual arrangement between the intending parents who want a child, to the fertility clinics, and to the surrogate mothers, right? I don't know if you know this, and this is something for Dr. Mallikarjuna, sir, because he's one of my role models and someone I'm a real fan of. Sir, we have always said in contract law, when we teach contract law, that consent is important. Free consent. We say coercion, undue influence, fraud, and misrepresentation and mistake vitiate consent. Consent is very important. But sir, you will be surprised to know that our surrogacy clinics have designed a contract in which they have what is known as irrevocable consent. Let's test public policy now here, okay? Because this is not, we don't have a judgment yet. I'm actually awaiting a judgment on this. So this is like an experimental case study for you. Now you must be wondering, sir, what do you mean by an irrevocable consent? Can contracts have irrevocable consent? Can you force somebody inside a contract? I think if somebody wants to come out of a contract, he or she should be able to come out of the contract. The consequence of the breach, yes, of course, you have to pay, right? But what do you mean by an irrevocable? Consent is there. What is irrevocable? Friends, the interesting part here is, it so happened, please note, in a case, I can't give you the name because confidentiality and so on and so forth. So a surrogate mother who accepted to take the embryo into her womb, she obviously signed the documents and said, okay, for the next 9 months I'll have this fetus in my womb, and then I'll hand over the child to the intending parents. Whatever is the compensation, I'll take it and go. But what happened was, in between, because of physiological challenges and changes, she changed her mind after 10 weeks. And without informing the fertility clinic and without informing the intending parents, she went in for an MTP, medical termination of pregnancy. And under that, her single consent was sufficient. Now, the fertility clinics have understood this case study so much that now they're saying, look, any surrogate mother must give us an irrevocable. That means she cannot revoke her consent within those 9 months. If once agreed, you will deliver the child and only then you will leave. The counseling actually insists on that irrevocability. That means it is a one-time agreement. You can't go back on it. Now, if you ask me, and if there are women in this house who believe in, right of women for medical termination, and you can do medical termination for the health of the woman, it is your bodily autonomy, you have a right to decide, and you can probably change that decision after 10 weeks. I don't think there is anything wrong about it. I'm not sure whether that irrevocable consent part in that contract should be held against public policy. Debatable. Most of us may think it is in favor of public policy, because once you agree to something, you better fulfill that commitment. But I told you about the physiological challenges and changes and problems that women face during pregnancy. Can I change my mind? And if it's good for my health, which is physical and mental well-being, why shouldn't I have the ability to do the same? What I intend to communicate, friends, with this surrogacy example is, contracts are being designed to protect one institution or one person as against the other. Who has made this contract? It's a fertility clinic who has made this contract to protect the intending parents. But does it look against the surrogate mother? Probably yes. And is the surrogate mother having a choice other than to sign the contract, because probably the bargaining capacity is far lesser as compared to what is there between the fertility clinics and the intended parents? So somewhere, I believe the role of public policy is to catch such mischievous clauses and terms in contract, to moderate business and human right interest. Because as I told you, it's the guardian of protecting private rights. Public policy is that guardian. And I think if the courts take this initiative of determining what is the level of public policy in India, I think to a larger extent, they would have served the interest of the legal system as well. The interesting proposition that I'm going to place before you, again, it's going to be a challenge of how is public policy protecting social institutions, or how is public policy determining social institutions? Okay, how many of you think that a prenuptial agreement is valid in India? Is it possible to have a prenuptial agreement? I've already discussed this several times, but let me again ask the audience. Let me see what response I get in the chat box. What do you think? Hey, Kamath, this is, if it's Aditya Kamath, the one that I know, that's an unfair answer, Aditya. Okay. Is prenuptial agreement valid in India? Why not? I'm one who always thinks that, we lawyers should always answer yes when a client comes and asks you this question. Nothing is impossible in India. It's always possible. Only thing you have to know how to make it possible, right? So why can't prenuptial agreements be valid in India? It's invalid in India. Many of you are saying, why is it invalid? See, I believe that prenuptial agreements are very much fine. If it's valid in the United States, why shouldn't it be valid in India? Because I think most of you are saying no, for the simple reason is I think you all believe that prenuptial agreements are against public policy, basically because what do prenuptial agreements do? They try to infringe certain rights that are given to women in terms of maintenance, the custody of the child, and so on and so forth, right? So I think that is where somewhere most of us think that it's not valid, right? But I believe that if you have seen the 2016 Bombay High Court judgment, the Bombay High Court has said prenuptial agreements can be enforceable in India, provided it does not infringe the rights of women that are granted by the statute, right? Let me give you one instance in which a prenuptial agreement can be valid in India and cannot or need not be opposed to public policy. If suppose, me and my fiance, right, we have our individual properties before marriage, right? We have enough money, immobile and And we want to keep it separate. We don't want to mix it as matrimonial property after marriage. We want to clearly keep it separate, segregated. A prenuptial agreement can be made in India for that purpose. But of course, maybe most of you have said yes, because to some extent, it may infringe the rights of women, right of children, the best interest of the child. It actually probably infringes family and social values in India. Right? So I think, again, public policy interference into social institutions like family, marriage, and then there is a contract that is actually designed in those circumstances, also raises the challenge of why the discussion on public policy becomes relevant and important. Of course, the issue on public policy is always based on public opinion, and to some extent, let me talk about one interesting clause when it comes to Section 27, the most popular section to determine what is public policy. So Section 27 of the Indian Contract Act, friends, says that an agreement in restraint of trade is void, right? It has always said that. And we always say whenever there is a violation of Section 27, there is a violation of Section 23 as well. And under Section 27, I'm sure most of you have read a lot of cases. But one of the most interesting clauses that you should do, the non-compete, the non-solicitation, the confidentiality, these are normal clauses, friends. I'm sure you have heard about them in other lectures. But the clause that I'm very interested in is called the right of first refusal clause. The right of first refusal clause. Right? It is RFRO clause. That's how in short it is called. So if you go to the Zahir Khan case, the Yuvraj Singh case, you'll definitely see how this right of first refusal clause comes into place. But look at public policy dimension over here. Friends, the courts have said that a contract cannot restrain somebody's freedom of trade, occupation, and business, especially when it comes to B2E contracts, that is business to employee contracts, B2E. But the same courts have said that the right of first refusal clause is valid when it is B2B contract, especially when it is about share transfer and restrictions on share transferability. So the same clause is valid in one case because the parties are in an equal position as against what parties are in other positions. So again, over there, what one will have to appreciate and understand, friends, is that the concept of public policy is quite fluid. It's quite flexible. And it is for the judges to determine where and how this test should be applied, which clearly brings down to this fact that the judges have adopted two mechanisms. One, if they think that the whole contract with its main purpose and object is against public policy, they have held the whole contract to be void. But where they found a clause to be objectionable as being opposed to public policy, only that clause has been read down, right? The doctrine of separation, the blue pencil rule, all of that has come into place. And any kind of operationalizing of that clause, the courts have clearly resisted upon. Now, I don't know how many of you understood that very small word in Section 27 of the Indian Contract Act, restraint. Friends, there are 16 cases on restraint from High Courts and Supreme Court on the word restraint. There are two sections in which the words restraint appear. Section 27, restraint of trade, and Section 28, where is restraint of legal proceeding. Again, let me talk to you about an interesting clause called the prescriptive clause. Has someone heard about a prescriptive clause by any chance? Some of you might have heard about it. Now, again, this is again a kind of a mischief that is being played in contracts, where parties are told that they must inform the claim within 3 months or 4 months. This is a kind of a mischief to actually dodge any kind of period of limitation, right? So this is a prescription of claims, prescription of defects. For example, let me tell you how this prescriptive clause operates in a real estate project. Now, in real estate contracts, you will notice that we have seen a lot of mischief by most of these builders, and that's why you have the competition law, the RERA law that is coming into place to actually regulate the builders in the real estate sector. But they actually had a ball game. They had a ball time of having unreasonable contracts and clauses. Today, in the real estate sector, they have what is known as the defect liability period. Right? It's for 5 years that a builder must repair any kind of defect in the structural aspect of the building. That's what the RERA law kind of gives a prescription about, the defect liability period. Most works contract with PWD also have this defect liability period. But now the law says you are liable for the defect liability period, but now what do these builders do is, they have really mischievously put this, that once you come to know of the defect or once the defect is identified, you must notify the builder within 3 months. If you don't notify the builder within 3 months, the builder's responsibility to repair the defect is extinguished. His obligation will be terminated. This is what is known as the prescription or prescriptive clauses. So the prescriptive clauses in some way try to reduce or diminish the liability of the other party, which is so prescribed by law. So the law will say one thing, but what I'll try and do is to play a mischief and reduce my liability in that. That also is one of those kind of challenges that have arisen in trying to determine whether a contract or a clause is in favor of public policy or not. Fine, friends, the last point. I'll close with this. There was a very interesting empirical study that was made in the US. And the empirical study said, if suppose public policy is determined by legislative action, right? It's defined by legislative action. How much successful can it be before the courts of law? Like, will the courts accept it and apply it, and will you succeed? This study in the United States said that you will succeed 66% of times if public policy is governed by legislation. But if it's not governed by legislation, if it's left to the judicial interpretation, then the success rate is just 34%. What does it say? It says that when legislature says it, it is codified, there is certainty, and then it is about interpretation and application. But if it's led to the courts or the judiciary, obviously there is some degree of uncertainty, some degree of discretion, some degree of whether it will be applied or not applied. And hence today, if you look at the competition law and even the Consumer Protection Act of 2019, to some extent, actually, the public policy in contracts have been codified. We know there is some kind of certainty already there. And the RERA is one such law that also has becoming, trying to define what is public policy in certain kinds of contract. So legislature, if they play a defining role, the litigations are more certain. The litigations have a clear outcome. And hence, in trying to lay the test of public policy, I think the legislature should play a very, very critical role. They must come up with more specific legislations on these, either on public interest or on public security or on public morality. That would go a long way in protecting rights and in protecting contracts and making a contribution to contractual jurisprudence. I need to close and allow some time for discussion if necessary. But let me ask you a couple of things. Now, we came across a very interesting rental agreement because this was a rental agreement in the United States, and the challenge was that this was an agreement between same-sex couples. And the United States judge, interestingly, here, speaks about public policy. He says, till same-sex marriage is legalized, this was a time before it was legalized in some of the states in the United States. So he says, unless the same-sex marriage is legalized, determining the element of this kind of an arrangement or agreement between this couple is a matter of public policy. So, I'm just closing with that kind of a dimension to only suggest, friends, that interestingly, when we say public policy, it's not necessarily of the public in nature or public in character. Public policy is probably quite personal in character at times, and it can actually determine the rights in between the parties so as to look at maybe what is the popular perception, popular opinion, popular sentiment, whether it is something that the consciousness of a society can be accepted in this circumstances, whether it is right or wrong, whether this kind of a behavior should be encouraged or not, whether this is necessary in national interest or not. And hence, the judges have used all these kinds of rationales to intervene and determine the levels of contract. Finally, I'll close by saying this, that it's not only the clauses, it's not only the contracts that are challenged on the ground of public policy. Interestingly, you will also notice the performance of a contract sometimes is stopped because it is not in favor of public policy. These are elements in government contracting. Right? You will notice that the contract per se is not a problematic issue. The clauses are not problematic issue. But we have cases in which the courts have intervened in the performance because they have found that the performance of the contract is not in favor of public policy. So that's an interesting, way in which the courts have come into, intervening, because of course, government contracts have a nature of public interest. Obviously, I cannot deny that fact. But it's not on the clause, it's not on the contract itself, but on the performance side of it. Right? This was a case very recently of 2020, in a case of substituted performance that was expected, and the courts have come down heavily and said that's not in public policy, and hence the performance need not be sought. So the attempt, friends, was to take some discussion. Unfortunately, I had some more discussion, but into the time constraint, I had to cut short that. But I think what is the purpose of my interaction is just to ignite your thought on these two terminologies, ignite your mind to read more, research more, apply the element of these two words. Maybe it's important that we have just understood the significance of this in litigation in a practice perspective. That's more than sufficient for me, right? And that's the whole attempt. But let me also say that the problem of this is not only in India. My research tells me that it continues to be a challenge in the UK, and it continues to be a challenge in the US as well. So we are not new to this challenge. And I think it's an interesting one. It keeps the subject alive. And I think that is the whole purpose of public policy. Thank you very much, friends, for your attention. Thank you for joining as well. If you have any questions, additions, some suggestions to make, I think we have a couple of minutes for that, I hope, with the permission of Vikas.
Two facets actually came out. One was that it was one of the sessions where the participant kept on increasing. It only shows that people shared it, that you should join the session, that the session is going on well. Number one. And number two, the way you have explained the Brojonath's judgment, and again, while connecting all these dots, I'm reminded that relying upon Brojonath, that equal pay for equal work, just as here in this the celebrated judgment of Jagjit Singh, again invokes section 23 and says it's against the public policy, you would be entitled for full pay. Then there's a judgment of Upton India versus Shami Bhan, wherein it says that let's assume an employee said, if you're absent for this much time, your services are terminated. It says it's again against the public policy. Services. Then again, where there are contractual employees, they say that you are joined for 89 days, your services can be are co-terminus after 89 days. Again, it's against the public policy. It's this. So taking the entire arbitration, the service jurisprudence along with this, it shows the amount of knowledge and why your books are well. And I will ask Mr. forgive me for the pronunciation is wrong, because I've been told by many people, Dr. Manika Arjun, what is his comments, and I've asked him to unmute himself. Yeah.
Thank you so much, Vikas, for inviting me on forum. Am I audible?
Yeah.
Yeah. At the outset, congratulations to you, and you have been giving a very important intellectual feast on every evening. Congratulations, and you have been doing a great job. And thanks, Sairam, for recognizing me on the screen and for giving me this opportunity. Nevertheless, I don't have a question, but I would like to offer my comments and responses on two aspects. One on the fluid nature of the concept of public policy. The other on the new concept Mrs. Sairam introduced now, rather started, excuse me, debate on that. That is irrevocable consent with respect to surrogacy agreements. I think, oh,
Sir, ಹೇಳಿ sir. Continue, sir.
ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ? Yeah, with respect to that concept, I hold a view that it should be held as against public policy when debated. For the reason, it's good that you went on to say voluntariness is there not even at the making of the contract. You almost went on to say even after making of the contract. If I am ready to bear the brunt of the breach, I have a freedom to breach. I really appreciate that idea. In fact, yes, however ridiculous it is, however wrong it is, so far as contract law is concerned, all that contract law looks at is, if you are ready to compensate, you can breach. We can say so in some way. Probably you would say by all means, you can say so. Well, that being the case, and on the other hand, since the freedom of the surrogate mother has to be honored, and there may be good reasons for that as well. Hence, I hold a view, since the idea of irrevocable concept cuts at the root of the contract law itself. In limine, it has to be dismissed. If not, let the courts hold it as the object of the act is against public policy. As such, it's void and unenforceable. Well, that's my response to the to be shaped law you have spoken about. And the next and important one is, I'm so glad that you are focused on public policy alone, though you started talking about contract law, which is very important and less spoken area. Since it's a matter of interest for me too, if you permit me, I will not be able to.
So do you want to share the screen?
Yeah, no. I can. Am I? Do I have permission?
Always yours.
Yeah, I have permission. Let me share this quickly and tell for the benefit of audience. I'm sorry, I have not noted the case here. It's so interesting that it comes back to your second question, namely, should public policy be legislated or should be left to the judges? I am of the view that it should be left to the courts. For the reason you did establish by quoting the statistics, 66 and 30%. What was established was certainty. Is the object to introduce certainty or to do justice in a given case? If the object is the second, since certainty is always not to be adhered to, rather some flexibility is required and the cases have to be decided on case-to-case basis. That being the case, I am of the view that there shall not be legislation in defining public policy. It should be left to the courts to decide. Interestingly, you must be going through this slide. Public policy is a vague and unsatisfactory term. I'm sorry, I'm not able to bring the case in which the observation is made. The test is so fantastic. Two twin touchstones of public policy are advancement of public good and prevention of public mischief. But who knows what is public good, what is public mischief? They are another set of vague words for which the fantastic test that comes is, which I'm very much appreciative of. These questions, namely, whether something is in advancement of public good, something is in prevention of public mischief have to be decided by judges, not as men of legal learning, suggesting that bundle up your legal knowledge and keep it aside. And then, as you must decide it as experienced and enlightened members of the community representing the highest common factor of public sentiment and intelligence. Probably this expression too needs interpretation, but it makes sense. Well, the rest you may ignore. I was very fond of bringing this idea before, and I was also suggesting that let the fluid nature of public policy continue. Let there not be any definition by any legislation, and let the courts continue to decide it on the case-to-case basis. I think with these two responses, without taking much time, I thank once again Vikas for giving me an opportunity to share my thoughts on a fantastic lecture which Sairam has delivered. Thank you. Thank you, one and all. Thank you, Vikas.
I have to thank Dr. Sairam for giving us a fascinating thought processes. And I'm reminded the last time we had connected with Dr. Mallikarjun was on 21st of February when we had wished him on his birthday.
Yes.
And he's a principal in the KLE college. So it's always a fascinating part.
True. If I can just, add to what Mallikarjun sir had to say. The interesting part of this dimension of flexibility with the judiciary is rightly said by Lord Denning. He said that, when judiciary gets this right, the judiciary can actually reflect the aspirations of every generation in determining public policy. So public policy is not the reflection of only one generation. Public policy is dynamic. It can change from generation to generation. And it must reflect the consciousness of the generation in the society. And hence, it can definitely be something that can be altered, modified, changed. And probably one of the reasons why the judges have been given the task of determining it so rightly under the law. Secondly, sir, when we talk about, say, I'll just talk about one such case study, which some of our participants or audience will be interested. In 2017, we got this IPL ticket. So what IPL ticket does is, it says that even if one ball is balled, you will not get a refund. So what had happened that time is in Bangalore, unfortunately, evening rains, sir, and the match was unfortunately not completed. It's hardly 40 overs. And within that 40 overs, so he came to us to say, can I challenge the IPL ticket conditions as being opposed to public policy? Of course, it's one-sided. Who has bargained it? Yeah. And just imagine if that's the condition. Even if one ball is bowled, you will not get a refund. No partial refund. No partial. Right? Now, the justification that IPL gave is, we are investing. The players have already come to the stadium. The sponsor was there. The Kingfisher beer bottle is available over there. Bangalore. Okay. So, guys, please forgive me. Because Ji, don't look at us in an envious manner. So, there is a Kingfisher stand. So, so we have spent the money. So, the fans cannot get it back. Right? But my point was, isn't a partial. So, sir, if you recollect, when I was reading how the Consumer Protection Act 2019 is trying to reflect on contractual rights, you will notice that the Consumer Protection Act 2019 makes an attempt to look at this kind of behavior. It says that if borrowers repay the loan early, you can't impose a penalty. That would be treated as unfair. Right? So I think this unfairness of contract, unfair trade practices, I think to a larger extent seem to have been clarified thanks to the competition law and the consumer protection law. Because, sir, you will notice we were talking of unfairness in contracts in two stages. One is the substantive nature of unfairness in terms of the clauses itself. Second is the procedural nature of the unfairness, because most of us have to sign on dotted lines, take it or leave it contract. We cannot bargain it. We cannot negotiate it. And today, even if you look at the insurance sector, if you look at the IPL, if you look at airlines, everywhere the consumer has no bargain on the unreasonable clauses that are there. And hence, I think the determination of public policy over that becomes very clear. For example, during COVID-19 times, the airlines refused to give a refund. They said you can rebook, but we will not give you a refund because the COVID-19 sudden lockdown came into place. So many issues do arise. I think yeah, it makes the subject interesting, sir, like you said.
Thank you.
We will take only 2 questions. One is by Rohit. Question: employment contract states that in event of shorter notice, the employee is required to compensate the employer based on the CTC, but employer asks the employee to leave and notice period is not served, then employer is liable to compensate on the basis of the basic pay and not CTC against public policy. What is your take?
No, I have not understood that question entirely. But
he says the employee, if he said, let's assume there's a 3 months notice period, and he says he gives 1 month, then he has to give, the employee has to give the full salary. Whereas if the company is to give a shorter period, then they only have to pay the CTC. I'll just read it.
No, that's what I said. So, basically, if I have to answer, my perception of public policy is that there should be mutuality of obligation. That is how I see it. It cannot have unfairness or an upper hand to the employer. That per se goes or defeats the whole purpose. So that's my understanding of the same. But I think you will see that such kinds of conditions are existing. Unfortunately, I remember a case that I often share it with my students. It's from Satyam Computers. And I often say this: had that gentleman from Satyam Computers not challenged his employment contract, we would not have got that beautiful case on employment bond. So people like me and you, unless we challenge it, we don't get the citation, we don't get a case law for discussion in lectures. So I think somewhere, if that unfairness exists, it must be challenged, and I think it must be put down. But again, let me tell you, there's nothing like an absolute fairness doctrine. Remember that. There's nothing like that. It never exists anywhere in no legal system. So some degree is fine, but if it's if it's so unfair that it shocks the conscience of a society, the courts will definitely intervene. So what you're probably saying is, I'm not sure. The details will have to be looked into. It has to be studied before a comment can be said. But I think this is a general answer that can be reduced to.
SRV legal. And agreement restraining an employee from joining any other company is held by Section 27 of the Indian contract. This is posted at 538 of the Indian contract. Kindly clarify.
Yeah, it is. It can be considered to be in restraint of trade, but depends upon, again, the details of the clause.
He has to read the judgment of the Zahir Khan, the famous cricketer. Precept India versus Zahir Khan.
Yeah. That
will give him some insights.
Yeah, that is about the right of first refusal. But I think what he's talking about is a non-compete clause. That has a slightly different, take.
No, but some broad idea flows from that Precept India versus Zahir Khan.
Yeah.
SB legal wants to. Yeah. That will be the last question.
Hello.
Yeah.
The question, and first of all, I would like to thank Mallikarjuna sir because he has always been a very good guide for me since these many days. Sir is my role model as well, and my senior Satish sir is also in this room, and I would like to thank him also. Anyway, sir, straightly I will come to the point without wasting the valuable time of all the honorable and respected speakers. Satish sir, namaste. Sir, my question is, see, there is a service agreement between the company, between an insurance company and the employee, in which there is a clause stating that the employee has to work for 2 years from the date of joining, failing which he has to compensate the company double the amount of the salary for the remaining period for which he is not going to serve. So what I want to know is whether that particular clause or that agreement is can be termed as unfair practice, or is it against the public policy, or it is hit by Section 27 of Indian Contract Act, wherein it states that an agreement in restraint of trade or profession is not valid. So I just wanted your seniors' input so that we can learn. That's it, sir. I rest my question. That's all, sir. I
Yeah,
rest my.
I was just waiting to be given the chance to unmute myself. So, you asked a full entire question of a chapter in that book. So that has several cases regarding this. This is a very common employment condition in most private sector contracts. It is called employment bond. Now they've changed the name to call it indemnity bond. If you ask me why they have changed it, because they thought the amount in employment bond is treated as liquidated damages. And liquidated damages under Section 74 have to be reasonable. So if you go to the jurisprudence, very cleverly, they have redesigned this contractual agreement and called it an indemnity bond. Indemnity, unfortunately, in India has only 2 sections. There are very less case laws on it. Indemnity amount need not be reasonable. We do not have too many cases that suggest so, right? Whereas damages ought to be always reasonable. The principle of unjust enrichment applies. So that's the reason now they have cleverly titled this as indemnity, which means for the remaining period of the term of the contract, you have to pay something, right? Double the salary, specific amount, 2 times, something like that. They'll clearly say it. The point is that the courts have consistently held that the bond is fine because it has to be justified. But when it comes to public sector undertaking, they've asked, why have you fixed 2 years? Why have you fixed 6 years? What is the basis of this term? What is the basis of the amount that you're claiming? Is it based for training? For example, there is a Karnataka High Court judgment which very clearly said, if it is an amount that is spent for training, then if you adduce the evidence regarding the same, that amount then can be recovered, because he has left too prematurely, and the employer has lost the service, and he has invested in his recruitment, and that can be recovered from the employee. So that justification, despite in that contract it was written 2,66,789 was held to be recoverable to the employer. That's how the High Court applied the rule over there. So the point is very clear that the conditions have to be reasonable, the conditions have to be fair, and the bond can be enforced.
Okay. Sir, I have one more small doubt, sir. With your permission, I would like to submit it. The thing is, my colleague himself, by name, his name is Vinayak Raikar. What happened? He went out of the office, okay, by telling the reporting managers that I'm not able to work under your what do you say, like under your irrespectable behavior, because the reporting managers have been very bad to him, and he left the organization. And the very next day, he received a termination mail from the head office. Now he is asking me to challenge the termination before the labor court. And there is a service agreement for him that he has to work for 2 years. As far as my knowledge is concerned, he worked there only for around 7 or 8 months or 9 months. So remaining 1 year, he was supposed to work as per the service agreement. But now what he is saying, because of the mental agony caused by the reporting managers, I left the job. And moreover, moreover, he has not been given any show cause notice as well. So now he is asking me to challenge that. So what I am thinking, so I want to take the inputs, like whether if that service agreement is valid, then question of challenging that before any court of law does not arise. So now he is asking for my inputs as well. So in turn, I am seeking your advice also, sir. Sir, kindly unmute, sir. Sairam, sir, kindly unmute.
In fact,
Yeah, I think, my opinion over there would be to challenge the unlawful, nature of termination or dismissal, as the case may be. See, I think basically the contract is an evidence, it's a document, it's a deed, right? But the actions based on the deeds are also relevant and important. For example, I can tell you about how the notice is served, what are the grounds of that notice. For example, in one case that we know of, suspension was undertaken, but no grounds of suspension were mentioned. Right? So I think see, actions are also something that have to be in tune with public policy, apart from the deed, the document on the contract. Both have to match. And that's why I said that performance obligations are also something that are determinant elements of public policy. Right? So,
sir, in that termination letter,
Mr. Malik, SVG, you can read the judgment of Aptron India versus Shammi Bhat 98 Supreme Court. And then there's another judgment of this thing which says that if it is an unfair agreement, and let's assume they say after termination of 2 days, it's bad, it has been heard in terms of section 23 to be bad. Just read that Aptron India 98 Supreme Court.
Yes,
coupled with the fact,
sir, in the offer letter, it is clearly mentioned that without giving any notice,
we will take your question
separately.
I'm saying we will take the session separately.
Okay, sir. Okay,
sir.
Okay,
the entire legal aspects.
Okay, sir.
Yeah. We will ask Dr. Malika to give his insights.
Thank you, sir.
Yeah. And,
sure, sir. Thank you for giving me an opportunity. Myself.
Yes, sir. I will ask Dr. Malika to express his views, and then we will part for the day. And tomorrow, keeping in view the latest judgment of what is famously known as Maratha judgment, do stay connected with us tomorrow to understand what has been laid down in Dr. Jayashree Lakshmana Rao Patil versus the Chief Minister judgment, to understand how the reservation and what is the law laid down there. And Dr. Malika would express his views, and before that we will say, keep on wearing your masks, get your vaccination done, and maintain the social distancing. That's the only thing right now be done. Yes, sir. Your expression, and then we will a formal vote of thanks to Dr. Sairam.
Thanks, Vikas, for inviting me once again. It's a double bonanza indeed. Well, I did give my responses to a couple of the aspects, and I thank you profusely. One last thing, since you give me the opportunity, I'm wondering, and according to me, piece of law under Indian Contract Act, under contract law, called the protective devices against unilateral or standard form contracts. Like, even though I have given consent, even by writing, though I have given consent, if the other party had plots to take away his responsibility from the fundamental duty under the contract can be challenged on the ground of fundamental breach. Like that, there are many protective devices, reasonable notice, fundamental breach. Sometimes the courts have said the terms are unreasonable, hence we call the contract bad. Since such a weapon, which according to me is the first piece of consumer legislation, that is not invoked very often with respect to some of the questions that are asked before going to 27 or 28, or even to making the courts to check public policy. Let's try to challenge the validity of the contract by invoking the flaws that exist with unilateral, or in other words, standard form contracts, and by invoking the protective devices that are evolved by the courts to guard the weaker party against the stronger party under these contracts called standard form contracts. I think with that note and giving that thought and making you think a lot about it, share my views on a very interesting subject that is close to my heart. Thanks to Vikas and Sairam. Thank you.
Dr. Sairam Bhat, who rightly has said that he has ignited the thought, and as they say normally in Hindi, "Agaz acha hoga to anjam to acha hi hoga." Once he has ignited the right thoughts, we will get the right moment for the thought process of the public policy, and he has given the bird eye view. One can always understand that and look forward, especially for the students and those who are in the law field or otherwise. They can also look forward because he has given some way forward. He has shown the right light, and we have to traverse through that entire distance. Thank you to Dr. Sairam Bhat. We are enamored by the fact that he accepted our invite. Yes, it was quite, we persisted. And that's what we had learned, that if you keep on persisting, you can always achieve. There's nothing impossible. Impossible, it says, I am possible. So, and he was kind enough, though he was not coming forth because of his personal engagements, but he was kind enough to give us a lot of resource persons who have shared their knowledge on this platform, and that's make us quite popular amongst the students. And after the session, I will request Dr. Mallikarjun we will have him on the platform on one of the sessions. And thank you to everyone. Stay safe, stay blessed. And tomorrow, to understand the nuances of the Maratha judgment and the reservation, the constitutional bench, do stay connected with us. Mr. P.S. Rajagopal, a senior advocate from Karnataka High Court, would share his insights on that judgment. Thank you. And thank you once again to
thank all the participants, and thanks to Vikas, and thanks to Dr. Mallikarjun as well. Thank you so much. Good day. Namaskar.